Good afternoon, everyone. Myself, Harsheen Anand, is your MC for today's session on mediation. I feel privileged to be the part of Youth Bar Association of India, and I extend my heartfelt welcome to Mr. Brian Speers and Mr. Sanpreet Singh Ajmani. Mr. Brian Spears is the most popular face in legal fraternity related to mediation and is the president of Commonwealth Lawyers Association. He practices as a solicitor in Northern Ireland. He works mostly in property development transactions. It is worth noting that Mr. Brand has devised and teaches the alternate dispute resolution and mediation to judges, solicitors, and barristers run by the Institute of Professional Legal Studies at Queen's University at Belfast. Sir is the one of the most experienced legal mediator in Northern Ireland. It is very kind of you, sir, to have the invitation accepted and gracing the event today. I also welcome Mr. Sanpreet Singh Ajmani, President, Youth Bar Association of India, who is a young and vigilant solicitor and mediator and have a dynamic personality. His words have always been a guiding light to all the students, and it is very kind of you, sir, that you have been watching all the sessions of the summer school since inception. I also welcome all the distinguished guests, Mr. Santan sir, Mr. Jitendra Mohan Sharma sir, who have graced the event today. I welcome all the participants, and moving on to today's session, I request Mr. Brand to kindly ventilate his views on the topic cross-border mediation. Over to you, sir.
Well, thank you very much, Harsheen, and good afternoon to everybody listening. It's a really great pleasure to have this opportunity to speak to you. I hope that we will have some interaction after I have made my comments on this interesting subject of cross-border mediation. I will also mention a little bit about the subject of mediation stroke arbitration because I was asked to do that. So it is really brilliantly well organized that you have a summer school program, and I give credit to who I will now call my friend Rahul, who is behind the organizing. And thank you, Harsheen, for those very elegant words of introduction. And I look forward to interacting through you with the students and those listening. So as you have said, my role in my working life is to work in Belfast in Northern Ireland, one of the constituent parts of the United Kingdom, but a very distinct jurisdiction in itself. And most of my day job is spent in this office dealing with property development work, business sales, financing. And while that pays the bills, what fills my passion is mediation and dispute resolution. And as a somewhat lengthy introduction to the main remarks, I thought I would share an experience that I've had in my professional life, which started maybe 35 years ago. There were two brothers in Northern Ireland of very powerful personalities who became each the joint largest house builders in Northern Ireland. And while they were together, they were unstoppable. However, in the way that family members often have, they fell out. And in the way that when brothers fall out, it can be very serious. This was a very serious feud between the brothers. And as a young, newly qualified lawyer, I acted for one of the brothers and found myself for the first maybe 10 years of my professional life here in every form of adversarial proceeding, whether it was in arbitration, whether it was in a local court, whether it was in the High Court or the Court of Appeal. The brothers hired their gladiators, who were their legal representatives, and they went into battle in a very litigious and adversarial way. And initially, of course, it is quite thrilling to be involved with parties who have the resources to litigate in a proper way, who have the drive to inspire their legal team to ever greater effort. And there's no doubt that adversarial competitive litigation can be interesting and can be exciting. However, as I matured in my legal practice and as the disputes became more and more intractable, I became disenchanted with the mediation process. And I became disenchanted because going to court involves complying with court deadlines and with court processes. Documents have to be prepared and lodged, and they have to be prepared in a particular way and lodged in a particular time. And when you get to court, sometimes the judge wasn't there and things were adjourned. Sometimes witnesses who were essential were delayed. There was a lot of hanging about and there was a lot of wasted time. And of course, if you are up the previous night to prepare for a hearing and then you find there is nothing happening, that is a wasted effort and it feels somewhat dispiriting. So I also found that the client interests were not really well served by this type of extreme adversarial litigation. I could see solutions that would have been better for the clients than going to court and having a judge make a binding decision. And so that period of the first 10 years of my life then culminated in attending a course in New York on mediation, where from Northern Ireland, which has a troubled social history at that time, I was one of 20 or so people that went for conflict resolution training at Fordham University in New York. And they assembled all of the great dispute resolvers, mostly from the East Coast of the United States, but in family law, in labor law, in the commercial world. And I found that really quite an eye-popping experience. This was fulfilling, this was problem-solving lawyering, this was satisfying, and this enabled me to exercise skills of persuasion, skills of influencing, and looking for the best outcome for the client in a way that adversarial litigation did not provide. And so I found it was like being a mature adult when you are mediating rather than in a room full of school children. It's a bit like now we do these Zoom calls and you take it for granted, although a few months ago we didn't, and you compare it to an old-fashioned conference phone call, which feels a bit old-fashioned now. And the difference between litigation and my new world of mediation from the mid-1990s was very stark indeed. So my journey also coincided with a change in the society of Northern Ireland, and we had a peace process facilitated by an external mediator, Senator Mitchell of the United States, and that culminated in what became known as the Belfast Agreement, and that was classic mediation with multiple parties, moderated by an independent neutral who at times challenged the parties, at times encouraged the parties, and at all times communicated effectively with the parties and the outside world. And so it appeared to me that both in my professional work, it was more fulfilling and better for the clients to adopt a problem-solving approach. And it appeared that within society, some good could come of adopting that approach. So with that in mind, and the context of mediation being embedded in me for the last 25 years or so, I have been asked today to speak about cross-border mediation and enforcement of agreements. And there are two principal areas that I wish to focus upon. One is the European cross-border directive. We in the United Kingdom are still part of the European Union, although, as you will know, with Brexit, we will exit the EU at the end of this year. The European Union has Directive 2008, number 52, on cross-border mediation. And I want to spend a little moment or two looking at some of the key elements of that directive. I then want to move on to the Singapore Convention on Mediation, which is a much more recent piece of work and was signed in Singapore in August of last year. So the difference between the context of the Singapore Declaration and the European Union Directive is that within the European Union, there already exists a relationship of free trade and free movement between the 30 or so countries that form the European Union. And although each of these countries are different legal jurisdictions, they are presided over by a European Court of Justice, and they have many freedoms to trade and move and to deal in financial services or agriculture or pharmaceuticals. And therefore, in that context, the cross-border elements are less pronounced than they would be if you were dealing with countries who were not within a trading bloc like the European Union. But nonetheless, it is instructive to consider how the directive was framed, and on that journey through the directive, we will pick up on some commendation about mediation generally. So, for example, in the recital number 5 to the EU Directive number 52 of 2008, it declares it has the objective of securing better access to justice, and justice should encompass access to judicial as well as extrajudicial dispute resolution methods. And at the last webinar I was honored to participate in involving Indian lawyers, I did raise the question of access to justice requires consideration of both what is access and what is justice. And I think justice can be seen to be wider than simply the justice dispensed by a court. The directive goes on to say that mediation can provide a cost-effective and quick resolution of disputes, and interestingly says that agreements from mediation are more likely to be complied with voluntarily and are more likely to preserve an amicable and sustainable relationship between the parties. And that is recital 6. Now, I want to just underline for you the words agreements resulting from mediation are more likely to be complied with voluntarily, because I will move on to questions of enforcement. And I actually think that that is something that many people not particularly well informed about mediation are over concerned about, that I have found that agreements made in mediation are generally complied with, and I will expand that point a little bit later. Whereas a lot of lawyers say, why are we bothering to mediate whenever we still then have to enforce the agreement, and that then takes us into court anyway. So the directive, other interesting parts from the preamble mention that if that is a goal of the directive, the member states in Europe have to provide adequate numbers of trained mediators, and there has to be effective quality control mechanisms. And those mechanisms should not hinder the inherent flexibility of the mediation process, the autonomy of the parties, and of ensuring that mediation is conducted in an impartial and competent way. And then finally, from the preamble, the directive says that mediation should not be regarded as a poorer alternative to judicial proceedings, in the sense that compliance with agreements would depend on the goodwill of the parties. And that's again worth underscoring when we look at questions of enforcement. It says that mediation agreement should not be somehow secondary to a court order, but rather that a mediation agreement should be as equally enforceable as a court or arbitration order. And so member states were encouraged to make provision in their national law that agreements in mediation were made enforceable. Coming to the directive itself, it describes what a cross-border dispute is, and simply where the parties are based in different legal jurisdictions. It defines mediation as being a process whereby parties reach a voluntary agreement with the assistance of a mediator, and it defines the mediator as any person asked to conduct a mediation regardless of the denomination or profession of that person. And then we come to the heart of this piece, which is Article 6, and it describes that member states shall ensure that it is possible for parties to request that the content of a written agreement resulting from mediation be made enforceable. The directive goes on to preserve the confidentiality of the mediation and talks a little bit about training and competence of mediators. And what we see, therefore, is that there is a desire to have an agreed definition of a mediation process, an agreed description of a mediator, a quality control assurance that mediators have been trained and recognize their role as mediator and not decision maker. And I will return to that at the end of my remarks on mediation and arbitration. And in preserving the confidentiality, that preserves a very essential part of the mediation process, because the mediator will learn from interacting with the parties confidential information from them, which can assist in identifying strengths or weaknesses of a party's position. So in the European Union, there is plenty of scope for cross-border mediation. All member states are asked to make national provision for the enforcement of agreements made in mediation, and that is within a pre-existing trading bloc. But what happens if you are dealing with parties who are in, for example, Commonwealth countries who are trading with each other and don't have an overarching trading bloc agreement like the European Union? And it was considered that those forms of more international mediation were losing out to arbitration. In 1958, there was a United Nations convention called the New York Convention on Arbitration, which made arbitral awards enforceable as if they were court judgments. And that gave rise to a great surge of commercial business being resolved between parties internationally through an arbitration process. And we have seen over the last 50 years or so a tremendous growth in arbitration centers, in arbitration organizations that have panels and will facilitate the appointment of an arbitrator, will discuss fees, will have disciplinary standards for arbitrations. And we have seen investor-state arbitrations where resolution of disputes is not taken to national courts, but to panels of arbitrators. And one of the attractions of arbitration, it was said, was that arbitration was now as enforceable as a court order, and therefore it had a status. Mediation against the competition of arbitration was therefore somewhat secondary, a poor relation. And we see that in the language of the European Directive. So the United Nations people looked at mediation, and as a result of the usual process of working groups and discussion drafts, eventually there came the UN Declaration on Mediation, and it was signed in August of 2019 in Singapore. It refers to commercial disputes which are defined in the convention, and it will apply to the to countries that have not only ratified, of which there were I think 54, but also signed, and to date there are only 4. Now let's not be too concerned about that. It will pick up and gather momentum as more countries become interested. And among those countries that ratified were the US and India and China. And so those big trading blocs are significant in that they have ratified but not yet signed. The UK, I believe, will wish to not only sign but also ratify, but couldn't do so because the European Union couldn't decide whether it would sign as a European Union ratifying entity, or whether each member state in the European Union would sign individually, but then that would create some imbalance within the European trading bloc. So we have a brand new convention for cross-border mediated disputes, which are commercial in nature, and which makes the status of an agreement reached following a mediation process as enforceable as an arbitration award, and one can take the agreement to the country where the enforcement is required and simply make that into a court order. There is no need to argue about what the agreement meant, or to satisfy the national court that the agreement is somehow, that they have found the terms of the agreement. The national court will simply adopt the agreement that was reached. So that removes the need to somehow litigate the question of the agreement, which of course takes away from the advantage of mediation in the first place. There are some concerns that were expressed that the grounds of challenge were either insufficient or would prevent effective enforcement. And within the convention itself, Article 5 of the Singapore Convention describes how the national authority, or competent authority in the language of the convention, may refuse to grant relief if the party asking for non-enforcement is under some form of incapacity, or the terms are not clear, or there was a serious breach by the mediator of standards applicable to the mediator or the mediation, without which breach the party would not have entered into the agreement, or there was some sort of failure to disclose circumstances by the mediator. And those were, to some extent, safety valves introduced, although for the most part, mediators will say, I believe, that an agreement reached following a mediation process, because the mediation process involves the participation of the parties, the active engagement of the parties in the solution that has been reached, and that they have agreed to that rather than find that someone has told them what to do, creates a very markedly different psychology in the parties. So if somebody tells you to do something, you can quite naturally either resent it or feel resistance to it. You know, they've got it wrong, they didn't listen properly, they failed to take something into account. We all know clients who are on the wrong end of a court decision will say that somehow this was an injustice, and they resent the decision that has been made if they are the losing party. But in a mediation, of course, there's no winner or loser. There are just parties that have reached an agreement. They have assessed that that agreement is better than the alternative, and therefore the compliance is, generally speaking, much, much higher. Indeed, one looks, really, one needs to research quite adventurously to find many challenges to agreements made in mediation. And the ones that you find are the exceptions to the rule and are of interest because they are few and far between. So I say in the conclusion of this little piece of my talk that cross-border mediation is very much a part of the international global trading that we are all growing up with and experiencing, and the generation of lawyers that are listening will take completely for granted. That there does need to be some overarching definition of mediation. There needs to be enforcement recognition to give it a status that is not the poor relation to arbitration. And there needs to be proper quality control, training, and effective mediators to make this option for parties in different nations who have a dispute to resolve their dispute in an effective and proportionate way. And let's not forget that disputes are perfectly normal. They are everyday events, and we shouldn't have a great alarm that we have a dispute. Disputes can arise through miscommunication, through misunderstanding, and through simply a lack of awareness of some of the parties to the concerns or the position of other parties, and that can be resolved in a mediation environment. Now, if I could move on a little bit to another aspect of cross-border mediation, which is not the big picture United Nations declaration and convention, but the more prosaic elements of, well, how do you do one of these cross-border matters? What is likely to be the practical problems arising? And one can see that travel today is much more restricted, but Zoom technology and other products such as Zoom can provide an opportunity to conduct mediations, and I have had recent experience of doing so. And next week we'll have a mediation between parties in Northern Ireland and another party in Germany, and we are conducting that through Zoom. It requires a very great level of concentration, and one does lose something by not having the people in the room, but nonetheless, it can be effectively done. What is another aspect of cross-border mediation is there can be some cultural elements of difference between jurisdictions. I remember giving a presentation in a conference in Kuala Lumpur, and I was speaking about mediation across the Commonwealth, and there was a group of maybe 60 or 70 people in the audience, and some were older lawyers, some were lawyers from Australia and the UK, and many were young, newly qualified or even student lawyers from Kuala Lumpur. And there were several young ladies present, and I have a style when I'm in a room. I like to wander about and interact with the students. But I found that when I asked a question of one of the younger members, particularly the younger ladies, there was a reluctance to engage and somehow an awkwardness about me singling them out and addressing them. And I became aware that that maybe was something culturally not familiar to those particular students. And I may be right, I may be wrong, but I did sense that there was a different response from some of the Australian delegates who were in attendance, and certainly from the UK people. And so a lesson I took was that one needs to be more culturally attuned in cross-border mediation. Of course, the language and accents can be difficult. And I'm hoping that my accent is not completely impossible to understand, but I do know that when people speak either more quickly or with a particular vowel sound, it becomes a problem of accent and understanding. And one of the great benefits and charms of the Commonwealth Lawyers Association is that so many accents from around the Commonwealth are presented to you, and it's lovely to hear a Trinidad accent as well as a Nigerian delegate speaking. And of course today it's going to be wonderful to hear the different accents from India, who will participate in our discussion in a moment. There is also lots going on in a person's face and in a person's either stillness or agitation. And that can sometimes be misread on a cultural basis, of people who what appears to me to be affirming something or agreeing, or maybe simply being polite, and actually they disagree. And in a mediation, you need to unpick the, if you like, the veneer of politeness and not wishing to offend or not wishing to be seen to disagree with someone who's a visitor to you, like the mediator or like me this morning. But from my point of view, it's very important to really understand what somebody actually thinks. And that can be difficult to read if there are cultural hesitations about either disagreeing or showing emotion. And I think those are elements of the cross-border mediation that I wanted to highlight without having any particular answers about them. One final point in cross-border mediation is this, that if it is intended to be as enforceable as a court award, you need to make the content of the agreement reached very precise, and there is going to be a new skill of drafting and of making the agreement reached so that one avoids vagueness or ambiguity, and one has very clear obligations and entitlements described in the agreement reached in the mediation. And that can be a little bit of a tension, because very often in mediation, you have some softer elements included. You might, for example, have a public apology as part of the mediation solution. You might have a non-disparagement clause, and you might have a general expectation that the parties would trade in good faith with each other. Now, those softer elements of an agreement are not uncommon in a mediated agreement, but are certainly likely to be less enforceable and more woolly, if I can put it like that, than one would expect in an enforceable court judgment. So I do think that where you are going to produce an agreement in a cross-border world and seek to enforce it, the agreement itself needs to be precise, unambiguous, and have clear obligations and entitlements. So just a final word on mediation and arbitration. And there is a process called Mead-Arb. There is also a process called Arb-Mead. And I must say, I'm starting from the viewpoint that I do not particularly like mixing chalk with cheese. And I don't particularly like conferences on arbitration and mediation together. They are two very different processes. I did participate just Monday before last in a conference in New York, again through this medium, and it was an arbitration conference with a bit of mediation thrown in, and that underlined to me that we are talking about very different processes. And two critical differences are that in an arbitration, as with court, somebody is going to make a binding decision. And that changes the psychology of the parties and the role of the advocates for the parties. Because where somebody makes a decision, you are seeking to persuade that party to decide how you want them to decide. And you are disguising maybe your bad points, and you are presenting the best face. And you are not necessarily revealing your weaknesses to the party making the decision. In a mediation, you are definitely going to be having a discussion about revealing weaknesses and about your confidential concerns about the case, and you're going to be revealing your position. The mediator is going to say, well, just for example, if the following was proposed, what would your reaction be? And you're therefore going to be revealing to the mediator things in confidence. Why? Because you know the mediator has no decision-making ability. You're going to be revealing yourself to the mediator and will be unconcerned because the mediator has no ability to take against you and decide because they don't like the behavior of your client in some way. Whereas a decision maker can have those influences. And I think that where you are advocating before an arbitrator or a court, you're going to be very concerned to keep information that's confidential properly confidential, and you're going to behave differently than you would in a mediation. So therefore, if the mediator suddenly becomes an arbitrator and makes a decision, that's a problem, because the mediator has received confidential information and was facilitating a discussion and not having a case presented to the mediator to make a decision. Now, I know those who say Mead-Arb is a good idea and can work will say that you don't just spring it upon the parties. This is something that is agreed in advance. But nevertheless, I find conceptually and intellectually there is such a fundamental difference between the role of the mediator and the role of the arbitrator that to find the mediator suddenly becoming a decision maker is something of a problem. Now, I know that when you have successfully spent time with parties, maybe over an entire day, you have gained their trust. You are seen by them as a person whose judgment perhaps they value. And each party says, look, we can't agree, Brian, could you not simply make a decision for us? And that can happen, and that then makes the mediator form a decision-making role, and where the parties are fully informed and fully consent and perhaps even are fully advised, then that it might be possible for the mediator to make a proposal and actually make a decision that the parties say, whatever you decide, Brian, we will accept. And I have been in that situation, although I have to say that I have always resisted it. So there is definitely a debate to be had. There are definitely competing views, but that's all I want to say on MEDARB. And seeing the time that we are at, I am going to stop now and hope that I have at least stimulated some ideas or thoughts and contributed a little bit to your knowledge. And I look forward to any questions or comments. And over to you, Harsheen.
Thank you, sir. Thank you for giving an excellent coverage over the topic. I believe that students and participants are going to be benefited with the information and knowledge that you have shared with us. So starting with the interactive sessions, I request Mr. Rahul to kindly unmute all the participants so that they can place their questions. Starting with Mr. Clint Colaco, you can place your question before the sir.
Clint, you may post your question. You may unmute yourself.
Respected sir.
Yes, Mr. Clint Colaco.
Am I audible?
No, you are not audible, please.
Respected sir, am I audible?
Your voice is not
yes,
clear, Mr. Clint.
Respected sir.
No, I think you should take the question.
Sir, my question to you is, yeah, respected sir, am I audible now? Am I audible, ma'am?
Yes, Clint, you are audible.
Hello.
Yes, you are audible, Mr. Clint.
Hello.
Hello.
Respected sir, my question to you is, can Sophia Hagia matter, can it be settled through mediation? And if yes, then which countries are good to mediate in this matter?
I missed the first bit, sir. I got our certain dispute suitable for mediation, but I missed the type of dispute that you mentioned. Could you repeat that, please?
Harsheen, you may ask the question.
Yeah, sir, I just asked his question on his behalf.
Yes.
Sir, Mr. Clint Colaco has placed the question, whether the issue related to Sophia Hagia has been settled through mediation. If yes, then sir, which countries are best to act as mediators?
Yes, I would need some, I don't know. I think that some of these extremely contentious issues are best resolved and will be resolved for mediation. As to which countries are necessary, I have found you need, the essential thing about a mediator is that the mediator has to be both neutral and trusted by the parties. And in our own situation in Belfast, we found that the mediator from the United States was both neutral and independent and trusted. And sometimes in the United Nations peacekeeping efforts, you see in hotspots in the world, you see great effort is made to get a respected neutral person involved. And sometimes I make a light-hearted comment that they often seek Norwegian mediators because nobody seems to have any problems with with Norway for some reason, but that's only light-hearted. The essential element is that the mediator must be trusted, respected, and neutral. And with those qualities, I think that it doesn't matter from which country you're involved, so long as you have those qualities at your disposal.
Thank you, sir. Miss Naina Verma, you can place your question.
Good afternoon, sir. Am I audible?
Yes, you are audible, Naina.
So my question is, in cross-border mediation, especially if the dispute is between governments of two countries, or if the dispute have a political angle to it, how do they decide that who will be the mediator, and what will happen if the countries do not do not have a one stand on who should be the mediator?
An excellent question, and it doesn't just apply to countries. Where countries have a dispute, you will have politics intervening and national interests and very deep considerations to take into account. And those are not present necessarily in commercial matters or in matrimonial matters, but what is still present in those matters is the selection process for somebody is just
Sandipika, please
unmuted
mute
there.
yourself.
So the selection process is always tricky. In the ideal world, you are going to have the parties reach agreement mutually as to who the mediator should be. And that is by far the best, because the parties jointly have agreed and therefore presumably are jointly satisfied with the neutrality and independence of the mediator. But where you don't have that level of agreement, there can be negotiation and strategy involved in saying, well, I don't want who the other side are suggesting, because they must have some reason for choosing Miss X or Mr. Y. So we will refuse to agree whoever the other side have proposed. And that is why there has been a growth in organizations, ADR organizations, which can appoint or nominate a mediator. So if the parties can't agree on an individual, they at least could agree on, well, let us go to the, whatever is the organization. In the United States, it might be the AAA organization, and they have, you know, something like 300,000 arbitrations and mediations annually, big business, and they, parties in dispute simply go to the AAA and say, we have a dispute, it's in this particular location, can you nominate somebody to be the mediator? And by going through an independent appointing process, you remove that individual position taking of the parties. So I think that the choice of mediator is unfortunately can be one for negotiation and disagreement, but I wish it wasn't that way. And I think that's even worse where you're dealing with national government disputes, where you've got political elements involved. But that doesn't mean, just because something is difficult doesn't mean it's impossible. And for example, I have been asked to be the mediator in a number of disputes in the Republic of Ireland, a different jurisdiction, the same geographical island, but I have mediated many disputes in Dublin. And particularly interestingly, law firm disputes where you get fallouts between partners, and they didn't want anybody from Dublin to know the nature of the dispute, but someone from Belfast was an acceptable neutral person. So it is possible to find neutral, respected, independent mediators, and I hope that where you have a dispute, you don't spend too much time arguing over who should be the mediator, but maybe an independent appointing entity is the way to solve that impasse.
Thank you, sir. Next question is from...
Ma'am, can I ask something else?
Yes, sure. Sure, Naina. Please proceed.
Sir, is it hard to maintain confidentiality in a dispute, in a cross-border mediation?
Naina, you are on fire today. These are brilliant questions. Thank you for that. Confidentiality in mediation is a huge issue. But you will recall that in my remarks about the European Union directive, it specifically mentions confidentiality. And so I will read from Article 7 of that directive, and it says, member states shall ensure that neither mediators nor those involved in the administration of the process, the appointing body, shall be compelled to give evidence in civil and commercial proceedings. And so that is intended to preserve the confidentiality of the process. And no matter where you are in the world, and certainly my knowledge of the Commonwealth, confidentiality, and you have an interesting question when it comes to, for example, anti-money laundering legislation, where lawyers are all part of that global obligation to make reports and to deal with information that their clients provide and then breach confidentiality by reporting what may be tax fraud or money laundering offences, then that is deemed to be a circumstance where public policy is superior to or trumps the confidentiality obligation. Similarly, in a matrimonial matter, if children are at risk, then the public policy imperative would require that steps be taken to protect children, and that is more important than protecting a confidential mediation. But for the most part, mediation is confidential. It is recognized by the courts as being confidential, and there are only very limited circumstances where a mediator can give evidence or make their notes available, and that is generally to try and establish, well, what did the parties actually agree, or one or two of the cases reference whether an agreement was actually reached. So I don't know whether that addresses your confidentiality concerns, but that's my response.
Thank you so much, sir. It's a pleasure hearing from you.
Thank you, Naina.
Thank you, sir. Thank you, Naina. Next question I'm going to place on behalf of Dr. Medisport. How cross-border matrimonial disputes are resolved through mediation? Does mediator supposed to have the knowledge about culture and laws of respective parties?
Excellent. The European Union Directive and the Singapore Convention do not apply to matrimonial disputes. They are specifically confined to commercial matters or to civil matters. So actually, there is no convention for cross-border matrimonial issues. There are some cooperations that if people are going to take children away, that there can be emergency injunctions granted to prevent that sort of activity, or if parties are moving bank accounts, there can be injunctions granted to freeze assets pending the outcome of any court consideration of the merits of a case. But there are definitely challenges for, but also opportunities for cross-border matrimonial mediation. I can well imagine, and it's not my particular area of daily practice, but I can well imagine that they are both suitable for mediation if you get the appropriate person who is respected by the parties, and they will need a very great cultural sensitivity so that the mediator can assist the parties against the backdrop of knowing what those particular cultural expectations are. That said, that having subject matter expertise is in itself an interesting mediation debate, because some mediation scholars would say that you don't need to know anything about the dispute whatsoever. You just turn up and facilitate a dialogue between parties who have a dispute. And the knowledge that you have is not subject specific, but it is rather your expertise of being persuasive, trustworthy, empathetic, and so on. Others say, but you only gain trust by being able to demonstrate that you have knowledge of the subject matter of the dispute. So for example, in a construction dispute, the mediator might be more instantly respected and trusted, and the parties might be more instantly reassured and calm if the mediator understands basic foundation piling or concrete geometry and chemistry, or can understand the vocabulary of construction in a way that enables the mediator to speak the language of the construction company that has a dispute. And I think there is a lot in that that could apply to a matrimonial cross-border dispute, where you have a need to reassure the parties that this mediator knows what they're talking about. This mediator gets the complexity of the dispute and can speak with the language of the sensitivities and cultural, what the culture of the parties brings to the dispute. So on balance, a mediator with the necessary knowledge, I think, would be required in a cross-border matrimonial matter. But I think, and especially in matrimonial matters, the qualities internally of the mediator in terms of trust, empathy, of being able to demonstrate that they understand what's going on, and often extremely emotional issues will be very critical in those type of disputes. So I hope that that gives some reflections on that question.
Thank you, sir. We are remained with two more questions. Other one is from Ms. Chetna Bhargava. Ms. Chetna, you can place your question, please.
Am I audible, ma'am?
Yes, you are audible. Please place your question.
Good morning, sir. I am Chetna Bhargava, a fourth-year law student, and my question to you is, with the United Kingdom leaving the European Union, how did it affect the relationship between the UK and other members of the European Union with regard to the cross-border mediation?
Chetna, it's a delight and very appropriate of you to bid me good morning, because of course it is just gone 9 a.m. here and the working day is starting in Belfast. The UK leaving the European Union will have an impact upon its relationship with the European Mediation Directive. Whether it will change the relationship and advantages that the directive brings is another question. But the UK will not be subject to European law unless it decides that it is subject to European law. And there has been a lot of talk about equivalence of laws will make the trade going forward in a post-Brexit world much more seamless and much less complicated. So it does make sense that if you have the United Kingdom's largest trading partner being on our doorstep, namely Europe, and it is especially true of Northern Ireland, where 100 miles that way, I can end up in Dublin, the capital of the Republic of Ireland, which stays in the European Union, and there is no hard border, there are no walls built. There are no border posts. I can simply drive for about an hour and 20 minutes and be in Dublin with nothing happening to me at all, no passport to show. Now, after Brexit, that will largely continue. The trading patterns and the movement of goods and people and services will continue, and therefore the need for some form of effective, recognized cross-border dispute resolving options will continue and will, I think, be all the more important. And we have that already in Ireland in some Intertrade Ireland bodies where I have spoken and where they are interested in trading disputes arising between what will be an independent UK and the European Union, need some relatively straightforward approach to resolving them. So while the UK will not be the subject to the directive, I am absolutely sure it will want to have a collaboration going forward and to ensure that if, for example, my German Northern Ireland mediation next week, if that is taking place post-Brexit this time next year, I'm sure that the parties will want to know that any outcome that is achieved, if it requires enforcement in Germany, will produce an agreement that will be recognized by the German courts. And if it is not, then I just wonder the willingness of a party in Germany to be happy to be engaged in a mediation process. So it's not all worked out. Like so much in the world today, we know that things are complicated, but nobody really has the answers. And whether it be post-COVID world or whether it be a post-Brexit world, the outline of where we're going is a little bit shadowy, but nonetheless, the logic of where we're going suggests that there does need to be some dispute resolving systems that are effective in a post-Brexit world.
Thank you, sir.
Thank you, sir. I'm obliged.
Thank you, Chetna.
Mr. Dr. KP, you may place your question, please. Mr. Dr. KP, can you hear us? Okay, I take the next question from Ms. Deepika Sharma. She says, as I'm in a noisy place, I cannot place my question. You may place on my behalf. Question is, what is the mechanism to enforce settlement in cross-border mediation? Are there any challenges involved in it?
Yes, there are challenges to enforcement because where you have a cross-border situation, you have national interests, you have concerns potentially that some jurisdictions' court systems are less efficient than others. Now, I'm speaking to an audience of colleagues from India. I would ask you to reflect on whether or not your court system is speedy and efficient, or whether there are any delays in arriving at court. And I would ask you to reflect on the cost of accessing the court. And the same questions could be asked in the United Kingdom, and the answer there would be, of course there are delays, and of course there is expense, and therefore having to enforce an agreement by going to a court is likely to be considered a problem. And that if the jurisdiction where you have the dispute doesn't have an efficient court system, it might make you encouraged to use an alternative process such as arbitration or mediation. But if you reach an agreement in mediation and need to enforce it, then there can be challenges in theory. Remember what I said earlier, which is that for the most part, if you have taken part in a mediation and you have reached an agreement that you yourself have helped to shape and draft and have actively been involved in agreeing to, then you really won't want to deny it, or you won't want to create a problem of enforcement because it's your agreement. But nevertheless, some commercial parties might take cold feet and they might say, well, goodness me, I made that agreement. Now, is there any way that I can escape from the consequences of that agreement? And Article 5 of the Singapore Convention does provide the grounds for a court refusing to grant relief. And that is if the terms are themselves unenforceable, if they're null and void, if they create an obligation that is not recognized in a jurisdiction, then the court asked to enforce it is likely to say this is creating an obligation that is not recognized in law, or is not final, or is an interim, is expressed to be an interim type of resolution rather than a final resolution, which is why I said that for cross-border mediations under the convention, the mediator needs to assist the parties to reach an agreement that is precise, is unambiguous, and creates clarity of obligation and entitlement. Other grounds for a court refusing to grant relief, which generated a lot of discussion in the working group and in the lead up to the signing of this convention, are that there was a serious breach by the mediator of standards applicable to the mediator, which breach results in the party reaching that agreement, but wouldn't have reached that agreement if the breach had not occurred. Now, I find it difficult to know what type of breach that would be, and particularly if the mediator has prepared the parties that if we reach an agreement, this is going to be enforceable. So good preparation by the mediator is important. And secondly, if the mediator is that independent, neutral, respected party that I have spoken about in terms of selecting. If the parties have also spent time in engaging with the mediator and have reached agreement, it's very difficult to see how a serious breach could arise without which the party would not have reached the agreement. Similarly, a court might refuse enforcement if the mediator fails to disclose something which raises doubts about the mediator's independence. And such failure to disclose had what is called a material impact on a party, again, without which the party would not have entered into the agreement. So let us say I am dealing with a mediation between a party in Germany and a party here, and I have some shareholding or investment relationship with the German company, and I don't disclose that, then that would be a bad thing. I should have disclosed that, and I should have disqualified myself from acting, but I don't. Then if that subsequently emerges, then that would in theory be a ground for a court saying we can't enforce this agreement because the mediator failed to disclose something material regarding the mediator's independence. So I say the cure for that is that the mediator needs to disclose who they are, what their interests are, and be open about their independence and neutrality. And I say the mediator needs to prepare the parties before the mediation gets going, so that if there is an unexpected conflict of interest, that arises early and can be dealt with early, rather than arises after the entire process, and then that jeopardizes the agreement that has been reached. So enforceability, yes, you can challenge it, but I simply ask rhetorically the question, why would you challenge it if you spend all day with a mediator reaching your own agreement, and the mediator is someone who has been either selected by you for their qualities of impartiality, and independence. I hope that that maybe addresses that one.
Thank you, sir. There is last question from Dr. Merisport A. He says,
before that, Harsheen, we have from Dr. KPK.
Okay.
He has unmuted himself. Now he may ask his question.
All right. This is the second last question. We'll take one more question. Does gender plays a role in mediation? If yes, which kind of disputes are preferably settled by female mediators? Please ask the question on my behalf.
Harsheen, you seem to have frozen a little bit on me, but I have heard the question and I understand it. And I think that there are some issues that one needs to be like the angels and fear to tread. There ought not to be any gender or race issue involved in being a mediator. What ought to be the sole criteria is, are you the appropriate mediator for this dispute? Are you well trained? Do you have the qualities that are required to be an effective mediator? And that should be the sole assessment, not whether you are of one gender or another, or of one culture or another. That said, I am sure that some parties would respond better to a female mediator than to a male, but that is not universally true. It might be thought, for example, in this series of mediations that I did, that a female mediator might have been more appropriate than me. I was involved in a series of mediations involving some medical accidents or alleged medical malpractice. And they involved a series of most unfortunate events where the child of a mother was born stillborn. And this, of course, had a very great trauma for the mother and the family generally. And they expressed that in a determination that the hospital treatment was at fault. And the mediation anyway was established. The medical professionals were very concerned that they had not discharged their medical professional obligations. The midwives were very concerned that huge distress had been caused to these mothers, and they thought that mediation was a way of explaining what happened, of hearing the grief and the position of the mother, and of providing by the process of explaining in a safe space of mediation, this is what happened, this is why it happened, these are the lessons that we have learned. And as a result of a very traumatic and emotional experience, we found a resolution was achieved, and there is now a plaque in the maternity hospital which contains words that arose following those mediations that were very meaningful to those mothers, that their experience left a lasting and a legacy for visitors to that hospital. And there was a little garden of remembrance created in the hospital grounds, which was also meaningful to the mothers. Now, would that have been a better mediation with someone who was a mother, a female mediator? I don't know. What was important to me was that I could understand at some level the process. I could facilitate a discussion between the mothers and the midwife unit, and I could preside over a reconciliation of in the end. And there was a very humbling apology given by the midwives that I think was very helpful to the mother. but it wasn't me doing that. It wasn't me having to do anything. It was simply the mediator facilitating a process and enabling a very difficult discussion. So I find myself giving that illustration without really answering the question. Of course, there will be brilliant female mediators. I have met many of them. And of course, there are brilliant male mediators. And what we want is brilliant mediators and lots of legal professionals to turn to brilliant mediators to assist in the resolution of the dispute.
Thank you, sir. Dr. KP, you may place your question before Mr. Brian.
Yes, ma'am. Am I audible?
Yes, you're audible,
Yes.
please.
Thank you, Madam Harsheen, Anand, and thank you, sir, Mr. Brian Speers, for making a wonderful, spontaneous overflow of the merits of institution of mediation. I will have a three-pronged question, brief questions. One is a general question, whether this mediation as an institution is still seen in the company of other alternate dispute resolution systems. Am I correct? If it is so, is it not required that it should have its own separate identity? One. The second is, I think a good mediator must be more a diplomat than a jurist, because especially in cross-border mediation, you have to accommodate views and interests entirely different. Then third is a particular question, how this new ecosystem created by the pandemic has altered the course of mediation. Thank you.
Well, thank you, Dr. KP. Those are three magnificent observations upon which we might be closing. And I hope that I will deal with them sufficiently for you. So mediation against other dispute resolution options, yes, it is sometimes described as a spectrum of dispute resolution options, ranging from just face-to-face negotiation, no lawyers, no advisors, no court, you just have a dispute, you speak to the other side and you try and resolve it, and from direct negotiation right up to the system that most states provide in terms of an independent judicial process. But along the way, there are many staging posts between those two extremes. There can be expert determination, where you seek out an expert and you just want them to determine the dispute, and because they're such an expert, everybody then says, we will be content with this expert's view. You can have a mediation process, as we've been discussing. You can have an arbitration process where it's a bit like a privatized court and all of the paraphernalia that goes with it, and somebody makes a binding decision. So I think mediation can coexist with other options along the spectrum, including MEDARB that we talked about. And as for whether it needs its separate identity, I absolutely believe it does. That there needs to be almost a profession of mediators. And not all lawyers will be good mediators, but many lawyers will be. And there needs to be some almost status for mediation that it's a profession in its own right. And my good friend Santan, who's listening, will recall that one of your Supreme Court judges, Mr. Justice Rahul, and I spoke in Singapore last November, and he expressed the view, which struck me at the time as being very insightful, that mediation as a profession needs to be established. And I know in the Commonwealth Lawyers Association, many mediator colleagues are interested in almost like a Commonwealth mediation group. where experiences across common law jurisdictions could be shared. So a separate identity. Let's not have mediation and arbitration mixed in the same conference. Although I was greatly intrigued by your Chief Justice at an arbitration conference, I think earlier this year, talking about mediation almost as much as he spoke about arbitration. And so maybe mediation can take over and elbow aside the arbitration people. But I do think mediation conferences should be on mediation and arbitration conferences should be on arbitration, and a distinct identity is helpful. I love the expression, Dr. KP, that in cross-border disputes, a mediator should be more diplomat than jurist. And if I may, I would like to take that phrase as one of my memories from participating in this event. So I agree. I think diplomacy is an interesting word to use for mediation and for being the mediator. And many of the diplomatic qualities need to be in evidence, I feel, if you're a cross-border mediator. So I really love that phrase. And finally, the pandemic, and has it altered matters? I think it must alter matters permanently. We have all become rather immediately familiar with technology. We can operate it, we can use it. Even old geezers like me can participate in a Zoom discussion and can do Zoom mediations. And traveling and the expense of getting parties to one place really has to be looked at very closely, even when travel is permitted once again. But even if travel is not permitted, the world continues to turn. Disputes must be addressed. Courts aren't really functioning well at the moment at all. And mediation ought to be much more used and is definitely something that could be more used. So I think we have seen a permanently altered landscape for online dispute resolutions, not in person, but I hope that the in-person mediations will return and will return soon. I'm conscious of the time, and that's all I have to say on your three excellent observations, Dr. KP.
Thank you, sir. Thank you, sir, for the comprehensive answers. And I had the great fortune to watch the video. You had a discussion with His Lordship Justice L. Nageshwar Rao. That was provided by Mr. Sandan, who is a close friend of mine also. Thank you, sir.
You are now a close friend of mine because of your connection to Santan, and thank you for listening to the Justice Rao interview. I found that really exceptional to be able to have access to one of your respected Supreme Court judges.
I'm also a senior advocate in the Supreme Court of India.
Thank you, Dr. KP.
Thank you.
Stay in touch.
Thank you all for organizing this good event. Thank you. Congratulations.
Thank you, Dr. KP. Thank you, Mr. Brian, for addressing and excellently settling the questions and queries. I think no corners of questions have remained unanswered. Now I quickly request Mr. Sanpreet Singh Ajmani to conclude the session and deliver his vote of thanks.
Thank you so much, Harsheen. Before I propose my vote of thanks, I just quickly borrow the message posted by one of our participants, Aniket. Anil has posted a message that on the occasion of World Day for International Justice, it was an honor to attend the meeting today. So, sir, it was an honor for all of us that you were with us today on the eve of World Day for International Justice. The keywords which I can quote here by our eminent speaker, Mr. Brain Spears, was, in mediation proceedings, there is no winner, no loser. At the end, both the parties, if they are satisfied, the degree of satisfaction is much higher. So this was an end to our 8th session. Now we are left with 3 more sessions. Tomorrow's session would be taken by Mr. Leh Ju Lin. He is Deputy CEO of Singapore International Mediation Center, and he would be speaking with us on the topic of pre-litigation mediation and mid-up. And before I conclude by giving vote of thanks to Mr. Brian Spears, I would also like to extend my gratitude to my mentors who are today with us, Mr. Jitendra Mohan Sharma, Senior Advocate, Mr. Rakesh Kumar Khanna, Senior Advocate, Mr. Santan Krishnan Sir. They all are excellent lawyers in Supreme Court and mediators. Thank you so much, everyone. Thank you, participants, for being with us.
Thank you.
Thank you.
Thank you, Brian.
Thank you.
Thank you, Brian.
Thank you,
Brian.
Jitendra. Thank you, Santan. Brilliant job, Harsheen. Thank you, Sanpreet.
Thank you, sir.
It was a wonderful narration of cross-border and the way you handled the questions. Great. And it is
Well, you're very
enlightening for
kind.
me also.
You're
Mr.
very
Rakesh
kind.
Khanna is also here.
Thank
Well,
you, Mr. Brian.
And there's Rakesh again.
Very
Great.
much.
All my friends are now appearing. How lovely to see you. Great. Well, have a wonderful afternoon. I'm heading off into my Friday day, and I look forward to seeing you all again. It's been really fantastic. Thank you, Sanpreet. Thank you, Harsheen. And thank you, my friend Rahul, who's still hiding.
Thank you so much, sir.
See you, Santan. See you, Jitendra.
Thank you, everybody.
Bye,
Thank you.
Bye-bye.
Thank you.
Bye-bye.
Bye-bye.
Thank you.
Bye.
Thank you, sir.
Bye-bye.